Come in.
Pranam, sir.
Sit down.
Thank you, sir.
When did you pass the LLB?
Yes, sir. Sir, I passed my BA LLB honors in the year 2018, sir.
What is your optional subjects in Bihar PCS?
Yes, sir. So my option subject was first. My option was constitutional law and administrative law. My second was transfer of property, trust, specific relief and equity, and third was constitutional law and contract law.
What is your best prepared in procedural law?
So, as such, sir, I have studied every subject as to the best of my knowledge, but sir, I am a bit more comfortable in C.P.C as compared to any other subjects.
What is difference between section and order?
Yes. Sir, sections are substantial in nature, whereas orders are procedural in nature. Also, sir, in case of any amendment in section, it can be done only by competent legislature, whereas amendment under orders can be done by the order of Honorable High Court as well.
What is difference between decree and order?
Yes, sir. Sir, a decree substantially and formally decides the rights and liabilities of the parties. A court, after hearing the case on merits and demerits of the case, then passes a decree which finally decides the rights of the parties. Whereas an order is not necessarily it decides the rights of the parties. A decree is passed primarily in a suit, whereas an order can be passed in a suit, in a petition, as well as in application as well. So, decree can be a preliminary decree and final decree, whereas order can only be an order. And also, sir, in cases of decree, appeal shall lie as a matter of right. Sir, from every decree and appeal lies. Whereas from orders, sir, it is not necessary. Only those orders which are mentioned under Order 43 and Section 104, only from those orders, sir, the appeal lies.
Any example or applicable order? Just like section 104, order 43.
Sorry, sir, I cannot recall it this point.
What is res judicata?
Yes, sir. So, res judicata means when a court, competent court, after hearing the case on merits and demerits, decides and passes the order, decree, or judgment in a particular suit, then the parties to the suit cannot file same suit in a different court based on same cause of actions. It will be barred by res judicata. So this is basically in the interest of the state to prevent multiple litigations.
And what is difference between res judicata and sub res judice?
Yes, sir. Sir, res judicata primarily bars the institution of suit, whereas res sub judice primarily bars the trial of the suit. Also, sir, in res judicata, sir, the competent court, after hearing the case on merits demerit, decides the decides the suit. Whereas, sir, in res sub judice, it is only the stay of subsequent trial. It is the former suit is being the former suit is being decided by the competent court, and the trial of subsequent is stayed. There are further more differences I cannot recall at this point.
What is precept?
Yes, sir. As defined under section 46 of the C.P.C, precept means when a court who has passed the decree and which orders and later on the decree has been transferred to the executing court, then the court which has passed decree gives direction to the executing court as to the attachment of the property of the judgment debtor, then such direction or order is called a precept.
And what is garnishee?
Garnishee, sir, in simple words, it can be said that debtor of judgment debtor is called garnishee.
And what is garnishee order?
Garnishee order is one under which the court orders the debtor of judgment debtor not to repay back the money dues to the judgment debtor, rather repaying it back to the honorable court. So such order given by the court is called garnishee order.
What is interpleader suit?
Yes, sir. Sir, usually a suit lies between plaintiff and defendant, whereas interpleader suit, as defined in the section 88 of the C.P.C, is a exception to it, which says that when two defendants claim adversely to each other, and the plaintiff in the particular suit does not claim anything except the maintenance and amount which has been incurred by him lawfully in the maintenance of the property, then the plaintiff files the suit in the civil court as to decide who is the rightful owner of the property. In such suit filed by the plaintiff to decide the title between the two defendants is called as interpreters.
Any example? Who cannot file an interpleader suit?
Sir, there are two exceptions. So, firstly, the servant cannot file against the master as to decide the title of the master, and secondly, sir, the tenant cannot file an interpleader suit claiming as to deciding the title of the landlord. Sir. These two are particularly exceptions to the interpleader suits.
What is necessary party and proper party?
Yes, sir. So, necessary parties are those parties which are essential for the proper disposal of suit, and without them there cannot be ultimate justice being done in the suit. Whereas proper parties are those parties which are not essential, though it is convenient for the court to make them party. But even without proper party being a party, the justice can be done. Yes.
And what is misjoinder and non-joinder?
Misjoinder, basically, sir, misjoinder means when the proper parties are not made the parties in a suit, then it is called misjoinder. Whereas non-joinder means, sir, where the proper party has not been made a party in the suit, then it is non-joinder, sir. Non-joinder of necessary party will be a nullity, whereas non-joinder of misjoinder of proper party will not be a nullity, because justice is ultimately being done in the suit.
What is counterclaim?
So counterclaim means mutual extinction of debts is particularly known as counterclaim, sir. Under Order 8, Rule 6A of the C.P.C, counterclaim is being put as a matter of right by the defendant, as a matter of defense by the defendant, to be precise.
What is injunction?
Yes, sir. Injunctions, as defined by eminent jurist Burney, is being said that it is an order of the court which restricts a party who is invading or threatening to invade a right of another party, and by such order he is being prevented from threatening or invading the right of the other parties.
What is the basic principles to issue the temporary injunction?
Yes, sir. So there are three fundamental principles. So firstly, sir, the balance of convenience must lie in the favor of the plaintiff. Prima facie there must be a injury. Prima facie there must be inconvenience to the plaintiff. Balance of convenience must lie in the favor of the plaintiff. So there is one more. Irreparable loss must have, or inconvenience must have been caused to the plaintiff by such an act.
What is fact in issue?
Yes. So in simple words, fact in issue is a disputed facts between the parties, which is being alleged by the one party and it is being denied by the other party. So such fact is called fact in issue.
And what is relevant fact?
So relevant facts are those facts which either by itself or connection with the other facts establishes relevancy of fact, and under section 6 to 55 of the Indian Evidence Act.
What is the role of relevant facts?
Role of relevant facts, sir, it facilitates the proof by facilitating how evidence is being admitted before the courts, and ultimately it provides a bedrock so that evidence can be taken, how evidence can be taken, and what all are relevant under evidence facts.
What is confession?
Yes, sir. Sir, confession as such has not been defined in the Indian Evidence Evidence Act. However, sir, Lord Atkin and Pakala Narayan Swamy has said that confession is one under which an accused substantially and wholly admits the crime or substantially admits the essentials of the crime. Then such an statement is called confession, sir.
And what is difference between admission and confession?
Yes. Sir, admission is any statement, oral or written, which suggests inference as to any fact, an issue, or relevant fact. However, sir, confession is one which substantially admits the crime or substantially admits the essentials of the crime. Admission can be related to civil law as well as criminal law. However, sir, confession is only limited to criminal law, sir. Also, sir, admission is straight away defined under Section 17 of the Indian Evidence Act, whereas confession is not defined. Also, sir, the evidentiary value of the confession is strong in nature if it is proved that it is being made voluntarily in nature. Whereas, sir, under Section 31 of the Indian Evidence Act, admissions are not conclusive proof. They only operate as an estoppel.
Section 24 Indian Evidence Act provides that the accused made by confession by threat, promise, the confession is irrelevant. While Section 29 of Indian Evidence Act, the accused made by confession by intoxicating, sacred promise, and confession is relevant. So both provisions are not contradictory.
No, sir, both provisions are not contradictory, sir. So, firstly, sir, under Section 24, sir, the threat inducement or promise, which is threat inducements of force, which is being used, is being applied by the person in authority, and that is why there is exclusion of relevancy of admission and confession under Section 24. However, sir, there is no force or there is no threat or inducement. It is being made voluntarily under Section 29. However, it might have been made under the state of intoxication or under the secrecy of promise. But the genuineness of confession is not disputed under Section 29, and that is why, sir, it is being made admissible. And that is why also, sir, Section 24 evidence is being excluded, sir, because it has been obtained by force, fraud by a person in authority, sir. That is the reason, sir.
What is evidency value of dying declaration?
So, evidency value of dying declaration is a strong piece of evidence. So, a few days back, there was one judgment of the Honorable Supreme Court of India, a bench led by Honorable Justice P.S. Narasimha and Honorable Justice Mr. C.P. Ravikumar. The case name was, I cannot exactly the case name, sir. It was said that when there are two conflicting dying declarations, and both of them were recorded by the magistrate, then the dying declaration which were made after the examination of the accused was held to be substantial and was held to be admissible in nature. So, sir, it can be concluded that dying declaration is a strong piece of evidence and it is admissible in law.
And what is difference between Indian law and England law?
Yes, sir. Sir, under English law, dying declaration can be made only when person has died, and it is relevant only when the person has died. Whereas under Indian law, it can be made as to circumstances of his death. Also, sir, it is relevant under civil law as well as criminal law. Whereas under English law, the dying declaration is relevant only under criminal law. Sir. There is one more difference. I cannot recall it.
How many types of examination?
Sir, under Section 137, there is order of 138 defines order of examination, which says that firstly there is examination in chief, then there is cross-examination, and then there is re-examination.
And what is the object of the examinations?
Sir, firstly, the main object of examination in chief is to remove the fear from the mind of the witness who is being appearing before the court, and that is why So examination is chief is being done by the person who has called the witness. Questions are being asked by him in order to remove the fear also, and in order to remove hesitancy as well. Whereas the main object of cross-examination is to test the veracity and authenticity of the witness who is being examined. And so re-examination is particularly done when there are some lapses in cross-examination or examination in chief. Then re-examination is particularly done to fill in the gaps.
What is leading question?
So leading question means those questions which a person is putting, which the person putting suggests an answer to those questions. Then those questions are called leading. The person who is putting such questions is suggesting answer at the same time. Then those questions are called leading questions.
Any example?
So example can be said that if a question is asked, is your name Mr. Rahul? And such type of questions are called leading questions.
And what is hostile witness?
So hostile witness means those witness who has been called by the party, and he starts giving evidence against the party who has called it. Then such person is being called as a hostile witness, and it must appear to the court that such a witness is trying to deviate the attention or trying to deviate from the facts of the case. If it appears to the court, then only such a witness is called hostile witness. It is not necessary that he must only give a contradictory statement, but to the satisfaction of the court, he must give a contradictory statement. If the satisfaction of the court is being proved, then it is termed as.
What is last section of Indian Independence Act?
Yes, sir. Section 167 says that no new trial for the improper admission or rejection.
Is it similar any provision in C.R.P.C or C.P.C?
Yes, so there are certain provisions which are similar to it. So at this point of time, we cannot recall.
What is bailable offence?
So bailable offence are those offences which are made bailable by any other law for the time being in force, or which are made bailable as per the first schedule of the C.R.P.C.
What is compoundable offence?
So compoundable offences are those offences in which the compromise between the accused and the victim can happen. So compoundable offences are mentioned under section 320, a list of offences under which compromise can be done between the accused and the victim, also without the consent of the court as well as with the consent of the court.
A new provision has been enacted.
Yes, sir.
Plea bargaining.
Yes, sir.
What is difference between plea bargaining and compoundable offence?
Yes. So, under plea bargaining, it is particularly commonly referred as sentence bargaining because of the nature that under plea bargaining, the accused admits the offence in lieu of lesser sentence, whereas under compounding offences, the accused gets acquitted. So, the second difference is that the acquittal and discharge, which means under compounding of offences, the effect is acquittal, whereas under plea bargaining, the effect is lesser punishment is being awarded to the accused person. Also, sir, under plea bargaining, there are certain categories like social economic offences, offences against women, or offences against child within the age of 7 years. So those offences cannot be. Plea bargaining cannot happen. Sir.
And what is difference between discharge and acquittal?
Yes, sir. So discharge means when after conducting an inquiry, the magistrate finds not sufficient evidence to proceed against the accused, then the magistrate discharges the accused person. Whereas acquittal means after hearing the case on merits and demerits, it is a judicial determination of acquittal of a person, means he is not guilty. Judicial determination of not guilty is basically called acquittal. And sir, discharge is basically done before the trial stage, whereas acquittal is being done after trial and it is the sentence. Sir. Also, sir, if a person is discharged, uh, it does not bar his subsequent prosecution of the same offence. Whereas under acquittal, once a person is acquitted, he cannot be subsequently tried for the same offence. So these are the fundamental differences.
What do you know by the remand?
Yes, sir. So remand is basically of two types. Remand basically means when the judicial magistrate applies his judicial mind to send the accused either to police custody or judicial custody. Then that application of mind in context to criminal procedure code is called remand. Sir. It can be a judicial remand or it can be a police remand. Sir.
What is the limitation period of judicial remand?
So judicial remand, sir, during the investigation stage, sir, judicial remand if the offence is punishable with less than 10 years, sir, then the maximum period for which accused person can be kept in the judicial remand is 60 days. Whereas if offence is punishable with life imprisonment, death, then the accused person can be kept in the judicial custody for 90 days. Sir.
What is bail?
Sir, bail is a security which is being taken by the court in order to ensure the presence of accused when the court requires or when it is being particularly required for the purpose of hearing or for the purpose of punishment.
And what is the difference between bail and bond?
Yes, sir. So bail is being particularly given to the accused person, whereas bond is being taken from the accused person to ensure his presence. Also, sir, bond can be taken from other person as well who is a friend or relative of the accused person. So, whereas bail cannot be given to the friend or relative. It can be only be given to the person who is charged with the offence.
What is the ground of cancellation of bail?
Yes, sir. So cancellation of bail can be done if the person who is being on bail commits similar kinds of offence. If the person who is being asked to appear before the court and to mark his attendance, if he fails to mark his attendance and appear before the police station to ensure his presence, then also, sir, his accused person can be the bail can be cancelled. So also the different conditions which are being put by the court, such as uh, not to travel outside the jurisdiction of the police of a particular area or a police station or a court. If the accused person moves out of that, then also, sir, bail can be. These are conditions under which bail can be cancelled.
What is the difference between culpable homicide and murder?
Yes, sir. So the first and fundamental difference between is the degree of criminality between the culpable homicide and murder. So under culpable homicide, death may happen or may not happen, depending upon the extent and nature of the offense, of the wounds, particularly. Whereas under murder, as per section 300, death is ought or certain in nature to happen. Inflicted injuries of such nature that in all circumstances death is going to be caused. So the degree is more in murder, whereas the degree of criminality is less in particularly culpable homicides. This is the basic and fundamental difference.
What is preamble?
Yes, sir. So preamble can be said as a brief statement, or as in the words of our founding fathers of the Constitution, preamble is the way to open the mind of the framers of the Constitution. It is being used when the Supreme Court, Honorable Supreme Court, is faced with any ambiguity. Then they use the preamble in order to remove any ambiguity or in order to solve any situation of constitutional crisis when it is being consulted. So in prime words, it can be said that it is a.
And what is the difference between constitution and constitutionalism?
Constitution. Yes, sir. So constitution is a supreme legal document of any country which has a special legal sanctity, and from that document, every other government of the country derives its powers and functions. Whereas constitutionalism is basically limited government. Essence of limited government is particularly known as constitutionalism, in which there is division of power. Also, every other institution under the constitutionalism is restricted in its own sphere. They cannot encroach upon any other institutions. A country is said to have a constitutional law, but it cannot have a constitutionalism like Middle East countries where there is monarchy system. They may have a constitution, but they do not have a constitutionalism because ultimately the monarch is the head of the.
What is difference between Article 32 and Article 226?
Yes, sir. Sir, Article 32 is provides the enforcement of fundamental rights by way of writs in the Honorable Supreme Court of India, whereas Article 226 provides enforcement of fundamental rights by way of writs and any other order as well. Sir, under Article 32, a person can approach Honorable Supreme Court for the enforcement of its legal rights, whereas through way of writs only, sir. Whereas under Article 226, a person can approach Honorable High Court for the enforcement of fundamental rights as well as for the enforcement of other legal rights as well, sir. So in that scenario, the Article 32 is quite narrower, whereas Article 226 is wider in comparison to both of them, sir.
Do you agree the corruption has entered in our judiciary?
So there are few cases which newspaper do report, but I have not heard of any such case, sir. So I cannot say that corruption has. So judiciary is still one of the most respected and prestigious institution of this country, sir.
What is curative petition?
Yes, sir. So curative petition is a petition which is also considered as a last stage petition, which is being filed before the Honorable Supreme Court in order to, as a last resort for seeking remedy by any person. Generally, sir, curative petition can be entertained by the Honorable Supreme Court only on few grounds. That is, if there is gross miscarriage of justice which is being done, or there is ultimate lack of jurisdiction, then only curative petition is being entertained by the Honorable Supreme Court.
What is complete justice under the Indian Constitution?
Yes. So under the Indian Constitution, Article 142 provides for the complete justice, which says that Honorable Supreme Court, for providing justice to the lower segment or for the enforcement of its order, so that if any provision is lacking under law, it must not create any impediment in the enforcement of justice. So generally, sir, Article 142 is being used in matters of matrimonial cases, in cases of divorce, sir, to provide complete justice to the parties.
What is casting vote?
Casting vote, I'm sorry, sir.
Due process of law
Yes, sir.
is not expressly used in any article,
Yes, sir.
but court follow hardly.
Yes, sir.
What is your view?
Yes, sir. So, when the constitution was framed, the word procedure established by law was used, and procedure established by law used under Article 21 says that procedure must be there. However, sir, the ambiguity arises when a procedure which is in itself arbitrary in nature, then the ambiguity arises, and the Honorable Supreme Court, precisely just Honorable Justice Krishna Iyer in one of the landmark judgments, I cannot recall, sir, he said that although the constitution makers have not used the word due process of law, we have borrowed it from the 7th Amendment of the US Constitution, and the Honorable Supreme Court in the landmark case of Maneka Gandhi has firmly established due process of law under Indian Constitution. Due process means that the law must be fair, just, fair and reasonable, as well as the procedure must also be just, fair and reasonable, and it must comply with the it must not be arbitrarily against any person, sir.
Our president is not a rubber stamp.
Yes,
As
sir.
an example.
Yes, sir. Sir, firstly, sir, in cases of there is no express article which mentions the discretion of the president. However, sir, when there are circumstances when there is no majority which is being formed by the government, then it is the constitutional discretion which is being exercised by the honorable president, and his discretion is there to call whatever major party or whatever political party he thinks fit. Also, sir, there are certain provisions like pardoning power under which, sir. Also, sir, the provision constitutional discretion can be exercised uh, while returning a bill for one time only, sir. In that, for reconsideration to the parliament, sir. In that circumstances, also, sir, constitutional discretion is being exercised by the honorable president.
Pardoning power is judicial concept or political concept.
So, pardoning power has been firmly incorporated under our Indian constitution, sir. So, I would say it is a judicial power of the honorable president provided under Article 72 and also to the honorable governors of the state under Article 161.
What is ground of natural justice?
Yes, sir. Sir, natural justice as has been taken from the common law concept. There are three fundamental grounds, sir, that audio ultram partem, first that the person must be heard. Also, sir, rule against bias. Also, sir, the third that a person must not be a judge in his own case. So these three are the fundamental principles. And if a decision has been passed against a person after hearing him, without hearing him, then he can challenge the same on the grounds of principles of natural justice. Also, a person who is interested in any case must not hear his case. This is a basic fundamental concept in regard to the Indian judiciary, sir. And the rule against bias means the person must be given reasoned answers, reasoned explanations as well regarding any decision which is being taken against him, sir.
Law is run on traditions. What do you mean?
Yes, sir. So, custom and traditions has been incorporated as under the meaning of law under Article 13, sir. So they do play a vital role in the evolution as well as transformation of law, sir. And in the Indian culture, the system of marriage, this system is basically a tradition which has been firmly incorporated under the law within the meaning of law, and this is being taken from the traditions.
Jammu and Kashmir
Yes, sir.
reorganization in 1929.
Yes, sir.
After enforcement, what is consequence?
Sir, Jammu and Kashmir is basically bifurcated, and Ladakh has been made a separate territory, and Jammu and Kashmir is being made as is being made a state without a legislature, sir. And the consequence is that every law which is being passed by the parliament is made applicable to them, sir.
What is immovable property?
So, immovable property as per Transfer of Property Act does not include growing crops and grass. And as per Section 3, Clause 22B of the General Clauses Act, sir, it includes immovable property, includes growing crops and grass and all the property which is meant to be severed later on, sir.
What do you understand by transfer of property?
So, transfer of property means when one person conveys property or interest in his property or conveys from one person to the another person, and such conveyance or act of conveyance by one party to the other living party, and they must be living. So, and the subject matter of the property which is sought to be transferred must be present. So, transfer of property basically means when the interest in property is being transferred from one person to another is basically called transfer of property.
Which courts has inherent power under C.P.C?
Honorable High Court under Section 151 of the C.P.C has inherent power to do the justice, to do the complete justice.
What is reason of origin of equity?
So the reason of origin of equity basically is, sir, in ancient times, sir, the matter was particularly decided or particularly adjudged one-sided only. Sorry, sir. Thank you, sir.
ठीक है, बेस्ट आपको